Okay, good evening, everyone. Welcome to our first APRA AMCOS Meet the Locals workshop for 2021. We're thrilled that you could be with us this evening. I am going to begin just by acknowledging the traditional custodians of the land from which I am joining you online today. That's the Gadigal people of the Eora Nation, and I pay my respects to elders past, present, and emerging. Thank you all for joining us tonight for this joint presentation between the Arts Law Centre of Australia and APRA AMCOS. Before I hand over to Suzanne Derry from Arts Law for the first session, I just have a couple of housekeeping points. Firstly, please keep your microphones on mute and your video off throughout the event tonight. Secondly, we are taking questions, but please send those as private messages in the chat to APRA AMCOS, you'll see the name there, to avoid clogging the general feed. Our moderator will collate the questions and ask them at the end of each presentation. This evening, you'll firstly hear about the Arts Law Centre of Australia, a non-profit organisation specialising in law pertaining to the creative arts. There'll be time for questions, as I mentioned, at the end of the session. Before we get into the presentation from myself, I'm Nikki from APRA AMCOS, and again, we'll have time for questions at the end. The entire webinar will wrap up at about 8 p.m. So let's get to it. I would like to properly introduce Suzanne Derry, the Director of National Partnerships and Senior Solicitor at Arts Law. Suzanne has spent over 10 years providing legal advice on copyright, contracts, defamation, and debt, just to name a few areas, to those of us in creative industries. That's going to be incredible, valuable information to all of us here now. So thank you, Suzanne. Please take it away.
Thanks so much, Nicola, for that really lovely, warm welcome, and thank you everybody for coming along. I know that it's, we're all a little bit webinared out at this point in the game, and so I think that any commitment of time on a screen is a valiant and brave thing to be doing on a Wednesday night. So welcome. Look, before I start, I also just want to acknowledge I'm presenting tonight from Lutruwita, which is Tasmania, and want to pay my respects to elders past and present and acknowledge the incredible privilege that I have on a daily basis of working with for and in collaboration with Indigenous artists, including some amazing musicians. I'm going to kick off by just sharing a bit of a screen with you. So fingers crossed that all the stars align and you can see the slides and still hear me, and I can still see what I need to see. What I'm going to do tonight is take you through a bit of a discussion about what arts law can do. We've been doing these workshops with APRA AMCOS now for a number of years, and it's always really been such a fantastic experience to work with their membership, because we find that APRA AMCOS are doing a pretty fantastic job at keeping the membership in a great state of understanding their copyright and their rights, and really good at referring people to us when they need help. So I'm going to start with a bit of a discussion about arts law, and then I'm going to talk a bit about music and law and contracts and all of those things. As Andrew said, if you've got questions, just shoot them through to APRA AMCOS. Sorry, as Nicola said, shoot them through to APRA AMCOS in the chat, and then they can sort of be fed through to me at the end, and we can cover them then. All right. So for those of you who don't know, Arts Law is a national community legal centre. We are the only national community legal centre for the arts. So we are the only federally and state-funded organisation with partners like APRA AMCOS that provide legal advice and education to the creative sector. And as you can imagine, in the last year, that has been a pretty bumpy ride. So we've really seen huge impacts for our musician clients, many of whom have had, 6 months of work that's been booked in advance dry up overnight because of COVID. So the financial and the contractual implications of the pandemic on the music sector, from our perspective, from a legal perspective, have really told a pretty horrific story. And I'm sure that I'm not telling you anything that you don't already know, whether it's your own experience or that of, you know, a friend or family member who is in the music industry. So the work that we've really been doing this year has been around helping people to understand those rights, in particular helping people to understand contracts and how they might pertain to things like bookings. But generally, arts law can assist with a huge range of things. Most importantly for you tonight, if you sort of step away from this webinar and just remember maybe one thing, what I'd love you to remember is that if you get into something that feels a bit like a legal pickle and you're not really sure, just contact Arts Law. We can help you to work out whether or not it's something that you're going to need to talk to a lawyer about, or an accountant or a manager, and we can distill the issues from a legal perspective to assist you. We will always do absolutely everything that we can to assist you free of charge. And Arts Law does have some subsidised, very low-cost services, including our review service for contracts. But it is really, really important that you know where to get help. So that's the one thing from me. I'm sure Andrew and Nicola will have take-homes that are key for this evening, but really importantly, from Arts Law, you know, it's just knowing where to get help. But do not log off. I'm not finished yet. We'll have a little while together yet. So in addition to being able to give you legal advice, Arts Law can also help to review agreements that you've been offered. Now, I think everybody who's attending tonight, anyone who is in this, the music business, will know that music contracts can be incredibly complex. So Arts Law has got these really great relationships with music law specialists, and we leverage those relationships to get you advice on those contracts. So whether it's a publishing deal or a label deal or a distribution deal, whatever it might be, we can assist you. The other thing that we can help you with just is sort of working around those agency and management relationships. We've had, you know, a number of those sorts of questions that have come through in the last year because of the stress that's placed on those relationships when bookings dry up, etc. Really what we're trying to do through providing that assistance is to help you to navigate your way through your professional your practicing career as a musician, regardless of how full-time or not that might be for you, and for you to encounter as few legal limitations to doing what it is that you love. And the way that we do that is really trying to get you confident and capable in terms of understanding some of those core rights that you've got, and also reviewing agreements that you might be entering into with other people in the industry. So look, I've given a little bit of a rundown, so I won't bang on about it too much. Just jot down the web address down the bottom there, which is www.artslaw.com.au. It's a huge website with a huge amount of material, and it's to some extent, unfortunately, what happens when you say to lawyers, okay, build a website that has all the things that people need to know. They take that very literally and create a website that is chock-a-block full of a lot of things. So most importantly, just have a look at the website around lodging a query. So there's a link on our site to a legal query form that you can lodge, and that's basically how you initiate a conversation about your legal rights or your questions. So tonight, you know, as Nicola was saying at the beginning, the chat that we have at the end, which I'm allocating sort of 10 to 15 minutes to, is not going to be specific to any one person's problems or questions. And the reason for that is that the relationship that lawyers have with people that they help, i.e. their clients, is sort of like the relationship that a doctor and their patient has. It is a confidential relationship, and anything that's shared in the course of their discussions is confidential. So I'm not going to be addressing any one particular person's set of facts and giving legal advice tonight, but hopefully this will be generally helpful to people, and it will give you the confidence to contact Arts Law if you'd like to have a chat with one of the lawyers at our service around any questions that you specifically have about your own personal situation. Feel free to ask general questions tonight, though. So, you know, a couple of years ago, I think, when I was looking at doing these presentations with APRA AMCOS, one of the things that, you know, one of the APRA staff had said was, don't take people through, you know, all of the detail around all of the things to do with copyright and contracts, which is what a lawyer is naturally inclined to do. We're not good on high level often. They said, talk to them about the things that they need to know, really, from a legal perspective. What do they need to know? And so with that feedback and that input in my mind, I went back and formulated really a very simple list of 5 things that you should know from my perspective. And we're going to talk through that list of 5 things tonight. So the first thing is that it is really, really vital that as a musician, you never sign something without getting advice about it first. It is incredibly common at Arts Law for us to receive queries from people who have signed agreements or made arrangements with other people or businesses or companies in a real hurry. And that happens for a number of reasons. You know, people are keen to be paid. Understandably, people are keen to move ahead and record the album or do whatever it is that needs to be done. And so they don't really spend the time looking at what it is that they're signing. That is a recipe for disaster, because what ends up happening is that you know, you can sign a contract that is actually not favorable to you, or that has parts of it that you don't understand. And then once you've done that, you're bound by that contract. And what that means is you can't kind of turn around 2 months later and say, oh, I didn't really read it and I didn't really understand it, so I want to get out. It's what I call the no backsies principle that we've got in Australian contract law, which is that if you're an adult and you sign an agreement, you're presumed to have understood its contents. So the other really important thing for you to do is to gather your information, to do your research, and to empower yourself to be able to understand these rights and interests. The lawyers at Arts Law and lawyers in private practice in this space are absolutely going to be invaluable to you. They are going to be able to assist you. They are going to be able to review agreements. But if you do not understand the very basics of what it is that you hold, which is so important as a copyright asset as a musician, you will always be behind the 8 ball, because you're relying on someone else's knowledge to empower you all the time. So I'm not saying let's do away with lawyers. What I'm saying is that it's really, really important that you also feed yourself as much information as is out there around copyright, contracts, industry standards. There's a fantastic book called Music Business by an author, Shane Simpson. It's recently been revised, and it is an amazing resource just around some of those business and legal issues. Know your collecting societies, talk to them. I really think that, you know, something that worries me is when I talk to somebody who is a member of a collecting society and I say to them, okay, so are you comfortable with what it is that they're doing for you? And they'll sort of say, well, I don't really know what they're doing or why they're doing it. I just signed up because that's what everybody that I know has done. It's really important to know what it is that those collecting societies do, because they are an important and imperative part of the ecology that you operate in. And lastly, but certainly not least, consider whether in your practice as a musician as a producer, as a music publisher, whatever your particular role within this industry or this space might be, consider whether there are any cultural implications that you might need to be aware of. And what I'm talking about is, the example of the sorts of matters that we see where you've got cross-cultural collaboration. You might have an Indigenous musician who's doing a co-write with a non-Indigenous musician and looking at some of the issues around the representations of cultural material in that space. Okay, so that was the first one was read things. The second one is talk to your band, and really not just your band. This is talk to everyone. Talk to anyone that you are making music with. Have a conversation about rights and money, and have that conversation early. The reason this is so important is that if you are co-writing with somebody, or you're about to step into a studio and perform with somebody else, probably one of the last natural things that springs into your mind is, what about the copyright in this material? Or how do I get paid? Or what is that 50% they've offered me a percentage of? And that's because you're focusing on the creative process. But the very tricky thing is that if you don't have those conversations early on, what can end up happening is that there can be really nasty surprises for people, and people's assumptions about the way that they're working with you, or perhaps your assumptions about what's going on, might not match theirs. And we see that happen all the time. And we particularly see it happen where you've got groups of people who've been playing together, sometimes for quite a long time. There's a sort of an unspoken understanding, or perhaps even a verbal arrangement around the splits for the songs. And then, somebody wants to leave the band, or there's a dispute within the band about payment or money. And it's all, it seems to me, the longer that I do work in the music and sort of legal space, that it's much easier to come up with an arrangement that everyone is comfortable with before there's an opportunity really to push the music and to push the money, or to receive money. Once there's money on the table, once there's interest in the music, and whether that's, a label, those conversations become quite intense, and it sometimes puts real pressure on the relationships within that collaborative space, because all of a sudden there's more riding on this than just what you all kind of thought was the arrangement. You've got somebody else that's involved, or you've got cash on a table that, everybody sort of feels that they're entitled to, and perhaps needs to be split up. So yeah, thinking about things like, collaborative names and band names and the rights in songs, and having an agreement is really important, which takes me to the next point, which is to write stuff down. And this is probably a really simplistic way of describing what I always encourage musicians to do, which is to get your affairs in order with the people that you work with by having written agreements with them. And I still remember doing this talk, a couple of years ago, and having a guy that was a musician and a producer sort of lean back and say to me, well, I really don't like what you're saying about this writing stuff down with the people that I collaborate with, because it's like you're asking me to sign a prenup with them. And he meant that as a sort of way of saying how distasteful it was to him to do this. But actually, to some extent, that is exactly what you're doing, because you're not just talking about your affection for each other as co-writers, or as a band, or as between, a manager and their client. You're talking about your professional career. You're talking about things that you are, a lifestyle and a career and an interest that you are pouring money and countless hours of your time into. And so talking to other people about having agreements when you are working with them is not a way of distrustingly asking them to sign a prenup. What it is saying to them, hey, we've got this really, really good thing going on, and we are going to spend time, and we are going to spend money, and we're actually serious about it. And I want to know that you are also serious about it, and I want us to be able to build something really important together. So getting a contract in writing with people that you do work with, whether it's, you know, a co-writer or a band or a manager or anyone that's producing any music or recording any music for you, is a really, really important way of protecting yourself and protecting them, and setting expectations for everybody involved that are realistic and helpful. So just to give you an example of where we've sort of dealt with this issue, we've had, you know, a band that had been performing for a long time. They'd been sort of taking on new members and really evolving in a way that is quite common, I think, for long-standing bands, where, you know, your guitarist might leave, you might have somebody new coming on board, the drummer stays, the vocalist stays, the bass player stays. Then eventually, 5 years down the track, the bass player decides to leave, somebody new comes on board. So each time that happens, from a legal perspective, what's happening is that there's this sort of new and changing space in which you're creating music with new contributors. And so from a copyright perspective, what is happening is that you are creating these jointly authored assets for the band. Those are the things that, you know, your label is going to be interested in, or your manager is interested that you've got, is the copyright in those songs. So it's really, really imperative in a situation like that, which is not uncommon at arts law, that you've got a great band partnership agreement with other people that you create music with, if you've got an ongoing relationship. Or if you don't have an ongoing relationship, that you've just got a co-writer, you know, a one-off contractor or co-writer agreement, depending on how that relationship is working. So arts law has got a lot of templates available, including co-write agreements, including partnership agreements, including agency agreements, all sorts there. So those agreements, as I said at the beginning, are not free. I think they're $100. But over the long term, they will save you really the stress of trying to unpick things if something goes wrong. And I know that, you know, Nicola may have some guidance for you around this when she's doing the APRA AMCOS part of the presentation. But really, you know, for a collecting agency like APRA AMCOS to sort of work with you when there's a dispute between members around what you're entitled to, that entire process becomes so much more streamlined and so much more sensible for everybody if there's an agreement that was put in place between the members of the band that talks about entitlements to things like royalties. So the other thing that's important is that if you are the kind of person who just listened to me say, we've got template contracts, and you zoned out or thought to yourself, I'm never going to do that. I can't present, you know, this person that I am writing music with, I can't give them a contract. I feel like I'd feel terrible about doing that. You know, hopefully you might see it a different way after the presentation. But if you don't, at the very, very least, trying to make sure that you have got your arrangements with other people documented somewhere in writing with them. So, you know, ideally you've got a written agreement that actually sets all of the terms out. But if nothing else, simply an email that actually sets out what it is that you understand you're doing for them, or that they're doing for you, is really quite important. And again, just really thinking about that psychology around your reaction to contracts. I mean, the music industry is probably one of those spaces in which the pressure that exists financially and from an industry perspective means that a lot of people do not use written agreements when they're working with somebody else. This is a way of you sort of putting your best foot forward. Having a written contract with somebody else tells them that you are taking this seriously and you take them seriously, and you're not just sort of spending your time and money on this as a hobby. And even if you are, you do still want to protect your rights and your interests. Okay, so hopefully I've sort of gone on enough about why a written contract is a good thing to have. I just want to touch on something quickly, because it's this really interesting sort of legal consequence of having a relationship with somebody else. And I know whenever a lawyer says the words, it's a really interesting legal consequence, everybody is sort of going, oh God, bracing for impact. But essentially what the law says is that if you've got an arrangement with somebody else that you've made verbally with that person, you probably already have an agreement. So the tricky thing is that you've already got that agreement, but if you haven't clarified what the parameters of that agreement are in writing, what happens is that you start to lose control over how that arrangement with that other person might be interpreted. And we see it all the time. So we see co-writers who, you know, one of them will come to us and say, look, when we wrote the song, the other person that I wrote the music with said that I would, you know, we just share 50-50. And that's a really common kind of, you know, we'll halve it or we'll cut it into thirds if there are three of us, which is fine until it actually has to mean something in dollars. Because if you don't describe what that percentage is coming out of, is it 50% of the gross revenue that you make? Is it 50% of the royalty proceeds that you get from APRA AMCOS? Is it 50% of the net proceeds once all the costs are taken off? So this, you know, okay, we'll work together and we'll share 50-50 is a really common thing. But unfortunately, it's less common that that is sort of clarified and the scope of what that 50% is coming out of is made clear. So think carefully about it. I think there's also sometimes a very interesting psychological barrier around contracts which relates to the earning of money from your art. And it is something that I have really been learning a lot from in the work that I do, because I think that very often as creatives, we might feel that asking for, demanding, or expecting money to do something which comes from us just expressing the person we are, something that we cannot not do, is somehow bad or compromising or you know, cheap or whatever that feeling is that this idea around talking about money taps into. And I definitely see it playing out with so many of the questions that we get at Arts Law, because I often talk with musicians who'll say, look, I didn't want to push about how much I would get paid. I just assumed that they would be fair. I assumed that the other person I was working with would be fair. And I didn't want to come across as being really difficult, and I didn't want to rock the boat, or I felt sorry for them, or they were amazing and I felt like the underling, or whatever that dynamic is that holds you back from having that conversation. So the tricky thing is that when the money then happens, when the money rolls through, or it might not roll, it might just sort of very quietly tinker, whatever sort of cash flow we are talking about happening, you then are presumably going to have the conversation at that point. And that is very, very difficult. So again, you know, super important that this conversation about money is not something that you feel compromised having early in the piece, because wouldn't we all rather be making money from music than doing something else to substitute that income? So one step closer to that dream is making sure that you are actually having good conversations about money and finances with the people that you're working with. Okay. Just very lastly, I think on that topic of the value of having written contracts, something that I've also noticed about drafting a contract for musicians is that when you send somebody else a contract, what you're doing is you're sort of laying bare all of the aspects of your commercial relationship with them. You're not talking about, how you feel when you play music with them. You're not talking about what music means to you. You're talking about the commercial and transactional aspects of your relationship with somebody else. And the really good thing about doing that is, firstly, that you can potentially reach an agreement. But secondly, that when you lay all of those issues bare, if the other party or the other person comes back to you and says, no way, I'm not, you've in this second part of the agreement, you're talking about sharing the money. I'm not sharing the money. Like, this is my gig and you're kind of coming along and it's just great for you for the credits. So if that's the reaction that you are going to get at the point that you're just having the initial discussion about how things work, it's so much better for you to know that now, right, than at the time, after you've spent a big part of your life and a big part of who you are on something like songwriting with somebody else. So I think it's really valuable to kind of preempt discussions as well. So number 4, ask for help. I've given a few examples of organizations there. Those are some Victorian examples, but pretty much any of your state funders would be a great place to seek help. But really, for the purposes of today's workshop, Arts Law for any legal questions, APRA AMCOS for any of your kind of collective rights management type questions, and don't kind of do what I do with a trip to the doctor, which is when I kind of wait until it's bad enough that I think it validates me going, so I'm limping in there or whatever else it might be, because I feel like if I go and I've just got like a slightly sore knee, the doctor's going to be like, it's not a real thing. Don't do that with your legal issues. So don't kind of wait until the arm is hanging off your legal relationship with someone else before you go, okay, I'll go and talk to a lawyer now. I can see that it's all gone really, really wrong. So the best thing to do actually is to just think of it like a legal health check. So wherever you are at the moment in your practice as a music industry practitioner, reaching out to Arts Law, going to that scary website that I mentioned. I can share in the chat at the end of the session just a direct link, so you don't even need to navigate all of the pages and the drop-down things. And just lodge one of those legal query forms. It's not going to cost you anything to do that. It's all confidential. And just, you can just tell us, look, I'm at the start of my career, or I'm working with somebody else. Nothing's gone wrong, but I actually just want to have a chat about my rights and my interests. Because at that point, what we can do is we can be saying to you, okay, great, you're songwriting with this other person. Let's talk about how copyright would work in that situation. Let's talk about what sort of contracts would be helpful to you. Have you got a manager? Oh yeah, okay, you've got someone who's interested in working with you. Is there a contract there? That sort of thing. It's really, really important to seek help. And look, if you do wait until the wheels are falling off, we are absolutely open to speaking to you then as well. So don't feel like, oh, I've missed the boat, and I'm just going to be now on this sinking ship to continue the naval analogies. Okay, so the 5th thing, which is probably the thing that you would all rather be doing right now, is to make music. Now, slightly less exciting version of that, which is really the version that I want to talk about, is that copyright isn't going to protect ideas or songs in your head. Copyright really protects things that have been expressed. It protects things that have been written down or recorded, basically. So if you are thinking of a really great song and you're performing it with somebody else, or you're looking at getting getting a guitarist into the studio to play one of the parts of the song for you, before you do that, make sure that you record a version of that song yourself. Make sure that you, and that might just be at home on Logic or Pro Tools or whatever you like to use, and make sure that you have an agreement with anyone who's going to be playing your music. If you're playing in a band scenario, make sure that you've had conversations about who shares that copyright and sort of how it works. So I think, the third bullet point there around surrounding yourself with talent as you work through is really important, because you've got to have good connections with good people to be able to navigate some of these legal issues. Although a lawyer is going to be able to help you to understand all of the legal aspects of your practice and make sure that you've got great contracts, that's not that helpful to you if you've got a manager who would throw you under the bus when push came to shove. So having good agreements around all of your relationships is really quite important. Also, don't use content or copyright material that isn't yours, because that can end you in lots of trouble. And we've seen lots of situations, especially there are certain genres like hip hop where there's lots of sampling of Marvin Gaye songs, or I think there was a recent one with the Tupac song that was sampled. So just be careful, because using samples of other people's music is a use of that copyright that they own, or that their publisher owns, or that their label owns. And so you've just got to be cautious about not getting yourself into hot water when you're using inspiration or other people's work. So just the key points: know your rights and get advice if you're not sure. Get agreements in writing, and don't sign anything until you've had it reviewed. Now, before I go to questions, I would like you to just spend a second having a think about those 5 things and see if you can just remember 3 of them and jot them down in front of you. So I'm just going to mute myself for one moment while you do that. Don't run away to the bathroom or for tea or beer or whatever else right now. Just write down 3 things that you can remember about what you need to do. So have a look at that first list that we had, and if you have remembered 3 of the things that are on there, or permutations of them, then well done, and brag in the chat. Feel free. I've picked up all 3 of them. I knew, or if you picked up 5, that'd be fantastic. All right, so I'm going to throw to chat now. So Nicole, if you've got, or Nicola, sorry, if you've got any questions that might have come through in the chat during the session. I'm sorry, I haven't actually been able to see the chat simultaneous to running the presentation and looking at the video, but I'm having a quick look now, so I've got that in front of me as well. Were there any queries that came through that you would like me to answer?
There are, and also what's come through is the sunshine into my room, so I will fix that up. We have had a couple of questions, so let me have a quick look here. Just having a scan through. The first question: when the time comes, does arts law cover sync licensing agreements as well as other types of musical contracts?
Yeah, we can give you advice about those agreements as well.
Mm-hmm. Perfect. A couple
And
of
we've got, sorry,
questions.
just very quickly, we've actually got if you're talking about sync to film or TV or, whatever it might be,
Yes.
we've got a template contract for that as well, which might be helpful to whoever it was that asked that question.
Definitely. And just as an APRA rep who makes this referral all the time, there's an excellent, not only the template contract on the Arts Law website, but Music New South Wales has an excellent checklist of things to consider with sync licenses too. Continuing down, we've got to confirm writing things down in a band agreement refers to the specific detail of songwriting, sound recording, royalties, etc.
Yeah, absolutely. I mean, the more detail you can go into in your written contract, the less detail you have to guess. The less detail you're going to have to dispute if things go wrong, and the clearer you're all going to be about what you're working towards and what you're working for. So writing stuff down, yes, talks about the money and the royalties, but it also talks about things like the responsibilities. So if you've got, a band member that is usually the one that's responsible for divvying up the money, or that has got control over the account, the band account, you need your agreement to talk about that. You really need a contract that's going to talk about credits, because that is one of the other primary issues that artists run into disputes around. Who gets the credit, who gets acknowledged, what happens if you're in a band where there are changing members all the time. Does the fleeting member who just happened to be in the studio on that day, do they get a credit? So that stuff can lead to lots of conversations and unfortunately sometimes disputes. So to any extent that you can include that in your agreements, it's really, really important.
And that actually leads really nicely into another question that has come up and certainly comes up on a weekly, if not daily basis at the APRA office, which was what is a typical breakdown of an agreement for songwriters? So the person asking the question, I think, is talking about royalty splits, and I will touch on this a little bit in my presentation as well. But Suzanne, if you have any advice you'd like to give on that front.
Yeah, look, I think I would say we see any and everything going. So I wouldn't want to say, oh, there's a typical breakdown and that's the formula you should follow. I think, perhaps because of the way that people register works through collecting societies, the view is often around the splits around lyrics and music, or this, as a sort of a 50-50, or whether it's a split around co-writes and making sure that if there are 4 members of the band, it's split 25% each way. But really we see any and everything, and actually something that's becoming quite common is also to see that's me not dodging the question, but just saying, look, there isn't a standard formula really in terms of your agreements with co-writers. It can be any and everything, and your registrations with collecting societies should follow whatever your agreement is. So if you've got an arrangement that the split is going to be a 50-50 split, then that's what your registration should reflect when you go to register with an entity like APRA. So it could be any number of ways of splitting it up, and it also depends how you as a band or how you as a collaboration value certain of those assets. Just so that you're aware, from a copyright perspective, the lyrics are a separate copyright asset to the music. So, the song from a copyright perspective is actually a whole lot of layers of copyright, which I haven't delved into the dirty detail on tonight, because I think, it's a bit heavy and a bit dry for the forum. But basically, when you're listening to a song, you're listening to a whole lot of different layers of copyright material. So you've got your lyrics, which are owned by whoever it was that wrote the lyrics, and then the music or the composition, which is owned by whoever it is that wrote that. So that could be 3 people, it could be 10 people, it could be 1 person. So that's a separate copyright. And then the recording itself is also a separate copyright. And that's why I keep saying, if you're working with a producer, make very sure that you've got an arrangement with that producer, because if you don't have something in writing with the producer and you are perhaps not paying them because they're a friend, the Copyright Act is going to make some decisions for you about how that music and how the song, the recording of the song is owned, and that might not be what you want. So yeah, good to get these things in writing.
Which actually then again leads into I think what is the final question here that I can see, and that was, in a creative environment, the splits are often worked out on completion of the track. So how do you work your way through this beforehand when it comes to collaborating? And look, yeah.
Look, I completely recognize that. And it's easy for lawyers to kind of lateralize what it is that happens in the creative relationship, because, you know, lawyers are thinking about the creation of those rights perhaps as a siloed event from what is actually a very complex creative relationship usually, and a complex creative process. So ideally, having a discussion with people before you are you know, going in to record that track, for example, about who owns the copyright is a good way to go. If you're sort of just perhaps performing in a much more domestic setting, and you've got you know, your workstation set up so that you can just record whatever it is that you're writing together, the law is going to make some decisions for you about who owns that recording. But I think generally, you know, it's a pretty big flag for you before you're going in to have any professional recording, mixing, or mastering done, that you've got an asset that you're putting money into. And so you need to have a good agreement about who owns that asset. So just you know, it's not a perfect process. Ideally, you have the conversation before you are making those recordings. But if the split, you know, if it happens that you haven't had the conversation and the recording's been made, and then you kind of are trying to figure out what the splits might be, you are a bit behind the 8 ball, but better to do it then than before you hit distribution. Because once you've started distributing the song and pushing it, and if you've got an agent who's helping you to do that, or a, you know, a distributor and an aggregator, once the money starts being generated, and even if it's a small amount of money, there are those questions about who's entitled to that money. So I recognize that the legal process and the creative process do not align perfectly pretty much ever, but you've just got to do your best to make sure that you are having that conversation about copyright and about money and about credits as early as you possibly can. Whether that's, you know, before you step into a studio or before you take your demo to, you know, to an agent, or whatever else it might be. Just really trying to have those conversations as part of your professional journey.
Definitely. And it's not always an easy conversation. I think that's something that I know you acknowledged it in your presentation just now, but should definitely be reiterated. And somebody has made a comment about, you know, doing it at the beginning, doing it at the end. What's more important than when you do it is that you do have the conversation and you do get something in writing. And if that happens after the song has been put together and you all agree on what the contributions that everyone has made should be and how those are going to be reflected in any royalty splits, and whether those royalties pertain to the actual songwriting or whether they pertain to the recording of the work, so any additional production that has been done to the composition itself. You know, you're talking about two different copyrights and two different lots of royalties there to be split. Again, whether it's happening before or after, as long as it's happening, I think is really the point to keep in mind.
Yeah, absolutely. And having the conversation and being clear about what you are splitting, because I think I said earlier in the presentation, people being offered 50% sounds very equitable and it sounds great. But if you're offered 50% of what essentially becomes nothing, that's not a great deal for you. So it's about being clear and sort of getting some advice. Someone's provided input that they are struggling to find an agreement, that a template agreement that's reasonably priced. I think I said earlier in the presentation, the templates that we sell on our website are $100 because it costs us money as a not-for-profit organisation to prepare, maintain, and provide those agreements. And so we don't apologise in any way for the fact that we charge a fee for those. It's what allows us to continue to do the work that we do. It's also what supports us in being able to provide free telephone advice to musicians when they contact us with questions and with problems. So hopefully, people understand that that's why we cannot operate on a completely free basis for the template contracts.
And Suzanne, I think, am I right in saying that there's also it's $100 for one, but if you become a subscriber, which I think is $250, you have access to multiple contracts. Does that sound correct?
Yeah, if you subscribe, you get the agreement for free, is what happens.
Right.
So,
okay.
And so, yeah, I mean, rather than sort of going into the detail around how that all works and which one's best for you, it's probably a good idea, again, as much as I'd love to send you to our website as a means of clarifying all of this, what I'd rather do is get you to contact us directly, and so that we can just explain to you which option's probably the most cost effective for you. But yeah, you're absolutely right, Nicola. So if people sign up to Arts Law, and the reason you would do that is if you actually wanted us to review an agreement for you, you would also then be entitled to a free contract as part of that subscription. Right. So that people are aware, because I think, sometimes we hear numbers like 100 and 200 and we think, wow, that's a lot of coffees, which it is. Private lawyers who charge for their time will bill out, at whatever rate their practice operates out of. So it might be $350 an hour, it might be $450 an hour, it might be $800 an hour. It depends who you're working with. So being and in recognition of trying to give people access to advice and to help that isn't going to cost them that kind of money, our service subsidizes, I suppose, a lot of that cost. But we can also give you referrals to private lawyers if that is what you would prefer. We've got amazing relationships with pretty much all of Australia's top music lawyers, whether it's Jules Munro or Chris Chow or Michael Easton. They're all people that we've got fantastic relationships with, who we would happily refer you to if you wanted a private referral. So that's also another option for you.
Great. And look, just as we're wrapping up, I think the only question that popped up right at the end was someone wasn't completely across how the copyright and the lyrics would differ from writing credits. So I think they were just saying that you were explaining about the composition as a whole actually containing layers.
Yeah, it does. Look, writing credits are different to copyright. Credits are essentially what you get to acknowledge your involvement and in the music. So your writing credit is the thing that you would expect to see on that, the details of that Spotify track or whatever it might be. Your copyright doesn't necessarily pertain to that. So you might, and I don't sort of want to overcomplicate things, but essentially, if you're a really famous artist and you are working with another writer who is perhaps doing all of the legwork on the writing, but because they are affiliated with you, this song is going to get massive exposure. You might, as part of your deal with that person, say, okay, we're going to co-write this song, And I'm going to be named as one of the famous person, or you the person with greater sort of market power. I'm going to be named as I want a writing credit, but your actual contribution from a copyright perspective may be really minimal. So the two things don't necessarily always line up, but in essence, if you write lyrics, what the law says is that automatically those lyrics will be protected by copyright, and you, the person who has written them, will own the copyright in those lyrics, unless you have an agreement with somebody else that changes that, which is what the scenario that I was just describing there. So I don't know whether you think, Nicola, I need to go into more detail there, because it's I don't want to sort of dive too far into any one aspect, but I also don't want to leave people short on things that they really want to know about. So
Sure. No, look, I think that's fair. I think if anybody has any other questions that they are unclear about, please remember you can always reach out to Arts Law directly. They do give free telephone advice. They've got their contact address as well on their website, which is just artslaw.com.au. I give that one out frequently. And of course, you can always reach out to us at APRA as well if you have any questions. So I think that was great. And if, I think we should move right along. Any other questions, please pop them in the chat, send them through to APRA AMCOS privately, and we can forward those on to Suzanne and get some responses to those as well for you.
can I sorry, can I just I've just in the chat, I've included our general kind of info email as well, which is artslaw@artslaw.com.au.
Fantastic.
And if you have questions, the best and kind of safest thing from a confidentiality perspective for you to do is either to use our legal query form on our website, or contact us through that email address that I've just given you. Because the tricky thing with passing legal queries through anybody else is that your legal privilege may be waived in the process of doing that. So if I could just ask you, if you've got a question that hasn't been addressed tonight, feel free to just email that artslaw@artslaw.com.au and get in touch with us, or you could use the legal query form. But look, thanks so much again for having me tonight. We really, Arts Law really is just so enjoying the relationship with APRA AMCOS, and it's been really fantastic to watch how that relationship means that APRA members are coming to us knowing lots about what we do, and we are able to cross-refer people to APRA AMCOS where that's appropriate as well. So many thanks for having me tonight. I'm gonna drop off and let you continue with the second part of the presentation, which I think will be wonderful for everybody. So thanks again. Thanks, Nicola, and thanks, Andrew.
Thank you, Suzanne. You have a good evening.
Yeah, bye-bye.
Bye. Okay, so moving right along, we are going to get into the APRA 101 session of tonight's webinar. I will be giving you just a brief rundown on some of the basics about APRA AMCOS as an organisation, or two organisations, as you'll find out in a moment. But I am also going to, this evening, spend a bit of time focusing on our brand new website, member portal, and mobile phone app, because these have just been launched. And I'm assuming that if you're here tonight, it's because you're an APRA member. So you might be interested to see a little bit more about what is actually now available to you. You might have noticed we have upgraded our website just recently, and we are constantly working to bring you new developments and new functionality. So without any further ado, let me start sharing screen, and away we go. Again, if you do have questions, please pop them in the chat, direct them to APRA AMCOS. We will collate them all and go through them at the end. All right, so right at the beginning, what is APRA AMCOS? It's actually amazing just how many people sign up to APRA AMCOS without knowing exactly what these two organisations do and what they're for. So APRA, the first one there, the Australasian Performing Right Association, as the name suggests, APRA is looking after your public performance copyright. This is the copyright that comes into play anytime a songwriter's words and music is performed in a public sphere. So that can be a local retail shop, that can be a live performance at a venue, a pub, or a club. It can be a little open mic night. It can be streamed on Spotify anytime that there's a public performance of music. APRA also looks after your broadcast right. Broadcast, of course, exactly as you might imagine, is anytime a radio station is broadcasting music or anytime that you have television broadcast. You've also got the communication right that APRA looks after. And communication is when there's a transmission via wire. So we're talking music on hold and even internet. Now, AMCOS, on the other hand, separate organisation, and as their name suggests, the Australasian Mechanical Copyright Owners Society, they are looking after the mechanical copyright in a composition. So again, copyright that belongs to the songwriter for their words and their music, but this time it's the copyright that is invoked anytime the song is reproduced in some way. Now that can be a reproduction such as a CD, a vinyl, like a physical reproduction, or it can be a stream or a download, like a digital reproduction. Moving right along. Oh, what's happened? There we go. In a nutshell, APRA AMCOS is working to ensure that whenever our members, and I mean our songwriter and composer members, as well as our publisher members, but wherever their music is being played or performed or reproduced anywhere around the world, we are there making sure that we're able to monitor the usage, collect any royalty that's due, and pass it along. That's the basis of what we do. We also, along with all of this collecting and paying, we are working constantly to try and ensure that our members' work is being recognised, whether that's on a domestic scale, but more importantly, on an international scale, because we might be a small continent or a small territory, but we do have some amazing songwriters. And of course, I'm thinking of everyone from incredible international acts like AC/DC and uh, Neil Sutherland, who writes for TV. I'm talking about Caitlin Yeoh, who writes for film, right through to Lord and Sia and Paul Kelly, names that have international clout. So we're always trying to work on different benefits and workshops, just like this one tonight, that can help our members to grow their skills and grow their network and ensure that their work is being promoted all around the world. Now, I've mentioned a couple of types of copyright, and that is because APRA AMCOS would not exist if it were not for the Copyright Act of 1968. Australian law is the whole reason our organisation exists. We don't make the rules. Australian law is there to say that if you are responsible for a public performance of music, there has to be permission for that use, and APRA is there to provide licenses that make it easy for that permission to be granted. I would say that the most common misconception that people have about APRA AMCOS is that you join with our organisation to copyright your work. This is absolutely not the case. As Suzanne has now made very clear for us, copyright protection in Australia and by extension throughout the world is free and automatic. As soon as your work is recorded in some way, and that can be written down, that can be something that you've got a proper mastered recording of. That can be something that you've just sung into your phone. Any sort of tangible format in which that work exists outside of your head is automatically going to qualify as protected by copyright. And now, should you ever end up in a situation where you, for some reason, have to defend your ownership, it's actually all of your rough drafts, your early recordings, um, any files that you have, emails that you might have sent of your early versions, all of those have got date and time stamps. And that is what you would actually take into a court of law and what a judge would be looking at when they're looking for the evidence to prove ownership of a work, not necessarily the registration with APRA, although of course that can't hurt your case. The other point on this slide that I do just like to note is that copyright exists for 70 years after the songwriter has died, and it remains with the songwriter. So after you've passed away, your next of kin or your beneficiaries, they're able to control the use of your work. They can give permission for it to be used, and they can continue to receive royalties. But actually, even after you've passed away, you are still the copyright owner, and that exists for 70 years after you've passed on. Now, we have again heard from Suzanne tonight, so I'm just reiterating. There are, of course, not only multiple copyrights in the composition, the words and the music, but there's copyright that is involved with the sound recording. So APRA and AMCOS are looking after the copyright in the actual composition. On the other hand, that sound recording copyright, that is administered by different organisations and quite often by a record label as well. This is where you end up with a difference between a songwriter receiving a royalty and perhaps a producer receiving a royalty. So while, for example, I might write a song and I might think it's a fantastic song, but maybe doesn't suit my vocal range, I might give it to my best friend and they go ahead and make a recording of that song and release it from their home studio. Whenever that song is then played somewhere, that recorded version, so it could be played on Spotify or perhaps they press up some vinyl, I'm going to receive any royalties for any time the song itself is used, but when that recording is used, they're going to receive the royalties for the actual recording that they made, the master, if you will. Now, moving into the real meat, what kind of royalties can you earn? So as an APRA AMCOS member, there are actually loads of different types of royalties that you might be entitled to. You've got live performance royalties, which is probably what we're most renowned for. That simply means whenever you're out there live playing your own original work, you are actually going to receive a payment from us for that. You've got radio and television broadcast, which I've mentioned, we license and therefore we can pay a royalty for. You've got streaming royalties. Obviously, not the greatest return on streaming royalties. I'm sure we are all well aware of that, but there is a royalty nonetheless. We will collect it, we will let it accrue, and when you reach a payable amount, we will pass it right along to you. Performances at major festivals and promoted concerts. Now, we pull this one out and give it a separate point here on the slide because the beauty of getting a spot on a major festival or concert performance is that these are licensed separately and at a higher rate than the gig you might be playing at your local pub. When you play at a major festival, that license fee that's charged is actually divided up between the total number of songs that's played at that festival, and every song receives the same rate. So the headline act is actually going to get the same royalty from APRA that the very first support act who went on receives. So it's quite nice, and it is usually a higher rate, which is great. Jingle broadcast royalties is another fantastic one. And of course, jingle work, if you can get it, is a wonderful return because you're looking at all different types of use. You're looking at television use, radio use, online use. All of those different types of performance all earn a different royalty. So we love jingles if you can manage to pick up some of that type of work. And then right at the bottom there, you've got the unlogged performance pool. Now, this one is an unusual one, but definitely worth bringing to your attention because unlogged is basically where you would look for any royalty that falls outside of one of these other more standard distributions. An example of this might be here in Sydney, we have the Vivid Light Festival. And for example, if your song was set behind one of these sort of art installations, perhaps out in a public space, the music is playing for hours upon hours, and it's most definitely open to the public, so you should be getting a royalty for it. But it's not something we would put into an art gallery license necessarily, or maybe even a usual council license. So we might have to try and look at some way of finding you a royalty that falls beyond the scope of our usual licenses. And that's what unlogged would be used for. There's a form on our website for that. You just fill it in, include as much detail about the performance as you possibly can, and we'll look into finding whether or not we can get a payable royalty for you. The other point to note here is that we do distribute payments at different times throughout the year. So if the royalty was collected within the Australasian territory, we have 4 quarterly payments that go out in, got to test my memory, August, November, February, and May for any of the domestic royalties. In between times, we actually do a smaller distribution on a monthly basis. And those monthly distributions will include any of your royalties from overseas, and they'll include any adjustments that would be made, perhaps even those performances at major festivals too. They would fall into a monthly distribution. Now, of course, coming back to that very top of our list, the number one top earning royalty stream for the vast majority of our membership is performing live. Despite the knockbacks that we had during COVID for the last year, this still is proving to be the case. The good news is live performances are starting up again. So if you are back out there and you are starting to play shows, you can once again start logging those live performances with us. It's really, really easy to do. You can even now do it on our brand new app. And all you're going to tell us is the name of the venue you played at, the date that you played, and then basically complete your set list. On the app, this is as simple as just swiping left or right, depending on whether you want to add the song or take it off the set list for that particular gig. In a normal kind of year, so we're just going to put 2019 to 20 to the side for a moment. A normal year, you would probably see a royalty rate of about $2.40, $2.50 per song. So if you think about 10 to 15 songs per set and however many sets you play at a show, sometimes you play 2 sets, sometimes you play multiple times in a week, by the end of the year, you can actually end up with a really nice royalty simply from performing live. Performing live can end up with members that have contacted me to say they have bought their APRA guitar for Christmas because we generally pay out the live performance royalties in November. So it can be a really good Christmas for some members. Now, this is another really important form of income, although, as we've now mentioned, perhaps not the highest generating one. Obviously, one of the main ways that people are now listening to music is via online streaming services. and there is a royalty to be obtained from these. It is really important to note that when you are uploading your music to websites like YouTube and Facebook and things, you need to ensure that their content management systems, so the YouTube content management system, for example, is recognizing your video as being a music video. If it's not categorized by them as a music video, it does not get reported to us. It would fall into general video category. And when that happens, it means that you are then competing with everybody's videos. And YouTube will only report music used in the top 1,000 streamed videos. So definitely ensure that your work is correctly categorized at their end. They do, however, give us a stream by stream report of every music video that is being played on the Australian branch of YouTube, which is amazing. And by extension, as I've mentioned, we are collecting for you worldwide. So we're also going to end up getting the data from the US streams, the UK streams, France, all around Europe, Japan, wherever it might be. Just takes a little bit longer to filter through to us because it's coming from those collecting societies overseas. The other thing to remember when it comes to streaming sites, and I mean Spotify and Apple and Google and all those sorts of sites, is that really to see a payable royalty, you need to be looking at about 10,000 or more streams within a quarter of a calendar year, so a 3-month period. And that needs to be within one territory. When you look at your particular stream rate, so you're looking at Spotify and you can see you have 12,000 streams, that figure there is cumulative. So that figure represents the total number of streams from when you first uploaded the song right up until today. It's also for the entire world. So it's really important to keep in mind that the data that we're receiving for our territory for a specific month or even quarterly period is not going to be reflected by what you're seeing on the website necessarily. What else can I tell you about online streaming? We do get every single stream reported from Spotify, Music, and Google Play. So rest assured, if your work is on there and it is streaming, we are receiving this data and it is coming in and it is being recorded, kept on file. Those royalties are being retained until they reach a point at which we're able to pass it along to you. Just noticing there too, of course, you are receiving a royalty for music used on websites like Double J. Any government websites, ABC websites, we get all the data for every stream used on those as well. Now, a little warning when it comes to using any kind of online service. Always, and I know Suzanne said this, always read those terms and conditions. And that is because sometimes, and not every website, but some websites, you are literally agreeing to allow your music to be used, downloaded, reproduced without any royalty going back to you. And I'm not saying these websites are bad and that you should avoid them. Bandcamp is one of them. But you should realize that when you're signing up to it, while you may be receiving an upfront sale price, you might not be receiving any ongoing royalties. Or you may be allowing people who download your music from that site to then go out and use it however they like or upload it to other websites. So always just be really careful before entering into agreements. Now, cover versions. I have great news about cover versions when it comes to online use. Here in our own territory, all of the audio only platforms. So I mean Spotify, Apple Play, Google, I'm talking about just audio, not YouTube, not Facebook. They have already taken out the mechanical licenses that you need to be able to release cover versions. So you can make your version of whatever song you absolutely love that you think you do just as well, if not better than the original artist, and you can pop it up on those audio only streaming platforms. This is also the case for pretty much all of the DSPs overseas, the exception being iTunes in America. You would need to obtain a mechanical license from Harry Fox Agency or MLC to clear the use in those particular instances. Now, the reason that I am very specifically mentioning that this is for audio only is because when you put a visual element to music, that can be an actual video or it can even be just an album cover, like a static image, you are immediately invoking what's called the synchronization right. And this requires extra permission. It is a different area of copyright, and it is something that has to be cleared directly through the copyright owner, which may be the songwriter. It is actually probably most likely to be their publisher. So it's a separate thing. And that's why you may find that your work is sometimes being taken down from Facebook or from YouTube. When it comes to physical copies of cover versions, so the cover that you released on Spotify is going off and people want to know, can they get it on vinyl? Yes, they can, but you do need to take out an additional license to make physical copies. It's really easy to do it though. Just go to our website. You're looking for an audio manufacturer license. All you do is fill in the application form. The license fee is based on the number of copies that you're going to produce. And it is actually quite a low cost fee. So you fill in the calculation, you will know before you hit submit exactly how much you're going to have to pay. And the license can be issued. It's as simple as that. Now, I did put a little bit in here about music being played on radio. And the reason that I've left this in is that a lot of our members do get radio play. Now, if you're lucky, you manage to make it onto commercial radio. And by commercial, I'm really referring to the Oz Stereo network. If you are one of the lucky ones who manages to get some airplay on a commercial station, you could be looking at some super lucrative royalties, anywhere up to even $20 per play. Commercial stations send us the reports containing every single song that is played on their station, and that includes the jingles. So we're getting everything and we're able to pay everything. But of course, as you can imagine, this is because commercial stations earn a great deal of money. There's a huge amount of commercial investment, advertising, and all that sort of thing. Therefore, we can pay out a much higher royalty fee. Sorry, royalty to you, not a fee. Now, community radio, on the other hand, these guys run very differently. They are usually relying on government funding and donations. And if we were to charge them a similar license fee to a commercial station, we would put them out of business. This goes against everything that APRA AMCOS stands for. But we understand that the vast majority of our members who are garnering radio play are getting it from community radio. And of course, this is where everyone starts out. You get that community radio play, you build some excitement, and that's how you end up getting commercial play. So, what we do for community radio is we ask that they simply send us reports of samples of what's played throughout the year. So they might provide us with a week's worth of data 6 or 8 times throughout the year. And if your song is reported to us in that sample data, you absolutely receive a royalty for that. Just recently, we wanted to make sure there was another way we could pay even more of our members who were being played on community stations. So we've started paying based on the AMRAP service. We found that 25% of community stations are actually using AMRAP to program their different their programs. So we found this was a really reliable way to see what was being played on community radio and to be able to pay more artists who were most likely our members. And we've definitely touched on this tonight with Suzanne, and there were a lot of great questions about working with co-writers. At one point or another, if not all the time, it's likely you will work with other collaborators and you will write songs together. If possible, do have that discussion before you start writing the song as to how you think the royalties will be split. But if you can't do it beforehand, the best time, right when that hit song has been finished, when the vibe in the room is really good, you've finished that final chord and everyone's getting ready to crack open beers and pop champagne because you've just written a hit. Definitely at that point, have that look around and be like, are we going equal splits on this? Or, you know what? This one, I only wrote the bridge. You took everything else. I think this is going to be 10% me, 90% you. Whatever the split is, it doesn't matter. What matters is you get it in writing. And although I'm sure Suzanne would hate to hear me say it, if you can't get a formal contract in place, anything is better than nothing. So if it's an email between co-writers, if it's a text message that you all reply to and say, yes, I agree, those were the splits we said would be recorded, fantastic. Anything is better than nothing. I cannot tell you how much of a headache this will save you later down the road. Another really good thing to consider is to get a little band agreement in place. And I say little, but actually they're quite a big deal if the band does break up. Or as Suzanne was mentioning, if the bass player leaves and another one joins, or the guitarist leaves. And what if that guitarist was the primary songwriter? Or what if that was the person that came up with the band's name? Can the band keep playing using their well-established name? Can they keep using those songs? There are quite a lot of things to consider. And I don't think anyone is going to be upset that everyone wants to take this seriously as long as you have those discussions when things feel good, as opposed to when they've already started to fall apart. Okay, here we go. I am going to make the grand assumption at this point that the vast majority of you are members, if not all of you. So welcome to the all new writer portal. To establish your, first of all, if you haven't already logged in to the brand new portal, you may find that you need to set up access to do so. From now on, you will not need to know your APRA member number to log in. I know, it's shocking, and I'm not sure that I've quite come to terms with it yet. All you will need from now on is the APRA address that is associated with your account and the password you created. Now, as you may have guessed, all new technologies mean all new security features. So if your password before was Bob, it's probably not going to work any longer. There are now criteria that your password may need to meet. Therefore, if you go to log in and you find that your password is being rejected, what you need to do is have an activation email sent to you. If you're finding that you can't trigger that yourself via the website, please just get in touch and we will trigger that email for you. But once you get that email, you literally click activate, follow the steps in the email, set a new password, and away you go. And once you're in, this is your new dashboard. So what you can see here is from the very top of the landing page, very, very clearly, you have 3 options there. One is to register new work. One is to view your payments. And the last one is to actually edit your account. So if you wanted to change your password, change your contract address or your mobile phone number, and it would be great if you did occasionally update these details, especially bank details, because we do need them. We love to be able to stay in touch with you. And most of all, we love to be able to pay you. So if your bank account details are out of date, please log in and give those a zhuzh for us. Moving further down the page, if you go into the Works section, you will see an all-new view. From here, you will see that there are two kind of works options. The first one there, very, very clearly, gives you the ability to view all your registered works. There is no longer a trick to this. You just click the button and all of your works will be available to be seen. The second option there with that little broken link, that is to view unregistered works. Now, this can sometimes be alarming when you see it the first time. Don't stress about it. Sometimes we receive reports from Spotify, for example, of a work that we think is likely to be yours. So we add it to your membership as like a fake or like a dummy registration. But only you as the copyright owner can claim that work. We can't do it for you. So if you see that there are unregistered works, have a little look at them. And if you're like, oh, that is my song, then please create a new work registration for it. That's all you need to do. Same as for a brand new work, you tell us the details and we will merge our dummy registration with your actual one. You will have no more unregistered works. I think the other thing that I wanted to mention here that I think is wonderful is that when you are viewing works, you can now filter them by co-writers, so by writer name, by title. You can search for a keyword in the title. And when you're registering a new work, you can now add your co-writer's IPI numbers. Some people might be freaking out, don't know what an IPI number is. Trust me, if you're a writer member, you have one. An IPI number is an 11-digit number that is used by collecting societies all around the world to identify you as a copyright owner and a content creator. We had lots of requests from people who had co-writers with very common names to be able to add in their IPIs. This was especially the case if they were co-writing with people from overseas. So you'll now find when you're registering a song, you can put the IPI number for your co-writers into the form. But please don't stress out. If you don't have their IPI numbers, you can skip on by. It's not mandatory. The other really wonderful new development is the amount of access you have to view your earnings. We call it Earnings Insights, but you can get to it via your member portal. When you first log into the area, well, you've already logged in. When you first get to the royalty statements area here, the overview page, this is the sort of information you will see displayed. So right up the top, oh look, there's that IPI number I was referring to. Your member number is there as well. You can see your earnings for our territory, New Zealand, and your international earnings. You can also see just underneath that the period that those earnings relate to. Right underneath this, you've got an overview. You've got an overview with a little pie chart or a circle chart showing your total earnings and a trend in earnings. So when you tend to earn more, when you tend to earn less. When you are logged into your own account and you're viewing this, you'll find that by moving your mouse across those pie charts and the trend chart, that it's dynamic, it's interactive. So as you move your mouse across, you will be able to get more information in regards to the amount that you're earning. So that's great. Even more information. Here we go. This is the reporting area. Now I've pulled out a few different screen grabs here just to show you, but in the reporting area, you will be able to see top earning works, earnings from digital platforms, which is what I've grabbed for you there. So you actually have a breakdown of what you are earning from each of the major digital online platforms. You can then, of course, again, move your mouse around and drill into more information. I love this feature. I think you will too. These dynamic charts are really good. You can see your earnings by track title, which is what I've screen grabbed there at the bottom for you. And you can filter that view again. So if you want to see all of the tracks that you and your best mate Bob have written, you can filter by writers and you'll be able to see the amount that those songs have written. You can also filter by category. So if you want to see how much your general works have made as opposed to how much you've made overseas, just tick those boxes and the reporting will adjust to show you the information you're requesting. I feel like people will be leaving this webinar right now to go and view all this information. And of course, a key element that has always been available from APRA, but now is becoming far more useful to you, is your ability to view your royalty statements. You have now 7 years of distribution reports that you have access to. Again, you have different ways you can filter them by country or by date frame. You can go very specific, you can go very wide, up to 7 years. You can also now, hallelujah, download the statements in Excel format and your remittance advice in PDF format. So it was a constant request from our writer members to be able to download Excel statements that they could then work with for tax time or just for general reporting. And now you have it. It's there, ready for you. I think we're doing okay for time, so I'm going to move right along to the phone app. I've already seen someone in the chat is here on their phone tonight, and I'm sure they're not alone. Everyone wants to be able to do everything on the go all the time. Where's my phone? It's right here. Mine's right here. I'm sure yours is right with you. So we have, of course, devised the APRA AMCOS app for music creators. Download the app onto your phone and you will find that you can log in, assuming you have already set up on the portal. So please go ahead and do that first if you haven't. But once your account is accessible, you can log in simply by using the recognition technology on your phone. So if you use fingerprint technology or face recognition, you can log into our app exactly the same way. Once you have the app, you can do so many things on the go. The app is working when you are working. If you need to register a song really quickly because you're in the room and things feel great and everyone's really happy and you've all decided to go equal 25% shares to all 4 members of the band that wrote the song, you can immediately jump on the app, register that work, include all your songwriters, and give them their shares. You can also immediately after the gig, because I know everyone wants to log some set lists immediately after they've played, maybe get a cold drink first, but jump onto the app. All you need to do is click to tell us the venue name. It actually starts to pre-fill for you because it's got the technology through Google. So it will probably know the name of the venue, fill that in for you. It's got a calendar. You just click the date that you've performed, and then to add your set, you just swipe right for adding and left if you accidentally added an incorrect song. You can add your own songs. You can add other writers' songs. So if you've been playing some songs by 9 Inch Nails and Bob Dylan, you can add them both. The other beautiful thing about this is you can view your earnings. As soon as you see that notification, the beautiful email from APRA that says, bing, bing, your royalties from APRA have been paid, you can log straight in and have a look and see what you got paid for and see how much it was, more importantly. And then I guess the other really nice thing, because we actually stopped making physical plastic membership cards quite some years ago now, but you have a digital member card on your mobile app as well. So all you need to do is click on the account there and a little card pops up. It's got your full member name, your APRA member number, that IPI number, and the date that you joined. I've already just seen someone in the chat said that they love the app, and you know what? That is the feedback we're getting. The app is proving very, very useful, so which is great because it's been less than a month since we launched it. Now I've thrown this, I've put this very important slide in here just towards the end, because one question that does tend to come up quite a lot is, where does the money that we pay, the royalties that we pay you, where does it come from? We're not government funded, and we don't take donations. We're not a charity. So where do we get our money? Quite simply put, it comes from license fees. So just kind of bringing this back in a big loop, the Copyright Act of Australia states that if you are putting on a public performance of music, you have to have permission to do so. We therefore made it easy to get that permission by having these licenses that we can put in place, and we charge a fee to take out that license. That fee then goes back to our writer members as remuneration for their permission to allow their music to be performed. Now, APRA AMCOS has been doing this for a very long time, since 1926, for our songwriter members. There is another organisation, of course, working with the same premise for their members who own that sound recording copyright, that master. That's the PPCA. Now, as much as APRA songwriter members love us, they love to hear from us, because generally, as a writer, if APRA is contacting you, it means we're paying you. Businesses didn't like to hear from us quite so much, because if APRA is contacting you as a business owner, it's probably because you owe us money, or you need to pay us money. Imagine then, you've not only had a call from APRA saying you need to pay money, but you also get a call from the PPCA saying you need to pay money. Therefore, the idea was, let's make this as simple as possible, as pain-free as possible. So APRA AMCOS partnered up with the PPCA to form One Music, thereby making a single license that businesses can take out to cover both the songwriting royalty and also that sound recording royalty. They're getting permission to use the copyright in all aspects of the songs that they want to play, and we're able to pay our members. It's less stressful and painful for them, and it means that we have, hopefully, more license fees coming in that we can pass along. Now, I do want to reiterate, it is a partnership. We haven't joined together. We are still separate organisations. APRA is separate to AMCOS. That's why you get separate payments. As an APRA member, you may not actually be eligible to join AMCOS. They're different. And again, you may not be eligible to be a PPCA member. They are different. But one license is much easier for a business. Now, I do feel like we are getting right towards the pointy end, and that there are a lot of questions. So I'm just going to quickly touch on some of the initiatives that APRA AMCOS runs, because we do a lot of collecting and paying of royalties. I think I've made that clear. But we also run a host of exceptional initiatives that benefit our members. And that can be everything from simply recognising how great their work is by running the APRA Awards, the Screen Music Awards, the Art Music Awards. But we also do some funding. We give away a little bit more money. We have the Art Music Fund. We have the Professional Development Awards, which is a grant of sorts as well. Please go to our website, type in grants in the search, and see if there are any offers being made throughout the year that might apply to you. We do a range of different things, and we are there trying to give funding that will support our members to further their songwriting. I think the Professional Development Awards are open at the moment, so have a look into that, because if you have some songwriting endeavors that you want to undertake, probably not traveling overseas with them, but maybe interstate, there might be some scope for you to be able to apply and get some funding to help you further your songwriting career. We also offer more grassroots, you know, benefits to our members. Workshops like tonight's one. So just simple informational sessions, right through to things like our Songwriter Speaks and Anatomy of an Album sessions, where we get some of our higher profile and ambassador members to talk about their creative process, to step you through how they go about doing a release from the very beginning right through to the actual final finished product. And we have an exciting program called Song Hubs as well, that again, on our website, type in Song Hubs, there is a little criteria there that you need to meet. It's an invite-only program, but it's a really exciting one where some of our writers that are starting to really take off can get that extra push by putting them into rooms with exceptional songwriters here in Australia and sometimes, travel allowing, overseas, and just letting them do what they do best, a few days in a recording studio to write and record and hopefully come up with a massive hit. I think that pretty much brings me to the end. So I'm going to stop sharing this screen and have a look at some of these questions. How did we go? Alrighty, I'm taking it from the top. Whew. Under the category of live, do all band members need to log performance reports or just one per group? The good news is just one per group. What we're doing is we need the information of the performance. Then everyone who was a writer of the songs that were performed at that show will receive their payment. So we only need to know about the performance the one time. Everyone's going to get paid based on the information in that report. If for some reason there's a bit of a double up and two members didn't communicate, we would see it as a duplicate performance and we would only pay one of them. So there's no point logging it twice. Can I claim live royalties for busking? The good news is that you now can. There are some councils who have begun to take out busking licenses with APRA AMCOS, and therefore we can now make a busking royalty available. So please go ahead and log those. And if your council has not taken out that license, by letting us know you are performing, we can go ahead and contact them and look into that. Do live performance venues generally pay live licenses? Yes, because again, it is actually Australian law. They have to obtain a license. As the venue is responsible for putting on the public performance of music, they are legally required to have a license to do that. So yes, and if they, for some reason, did not take out that license, then while we don't like to have to do it, but technically we can actually pursue them for that license and to pay the fee. It's probably good that I mention as well, even if the venue, you know, doesn't pay its artists or the artists that perform there only play covers, that still falls under our repertoire. Oh my goodness, that still falls under our repertoire because we have those reciprocal agreements with the other collecting societies all around the world. So we still need to pass along the royalties to those songwriters overseas who wrote those cover songs. Just having another quick look here. Isrcs, what are they? How are they relevant for YouTube, Spotify, etc.? Okay, so an ISRC is an international standard recording code. This code only applies to recorded versions of songs. You have different ISRCs for different versions, recorded versions of a song. Now, this can be different versions, as in the album version, the live version, the techno remix version, but it can also be the Spotify version, the Apple version, the YouTube version. And you'll find that a lot of digital service providers will actually create their own ISRC and attach it to your digital release of a song. That information is fed back to us at APRA. We attach it to your original registration. And the only purpose of an ISRC is to make matching of performances easier. So you've got one song and it's called Hooray for Sunshine. No matter whether Hooray for Sunshine, the live version is played, the Spotify version is played, the techno remix is played, every single version is going to be reported with a different ISRC, and all of those ISRCs are attached to your original registration. So it's all going to match back to that one registration. So the correct songwriters of the song will be paid no matter which version has been performed. Are ISRCs the same as IPIs? No, they are not. So again, an ISRC is attached to a recorded version of a song. An IPI identifies a songwriter. So I would have an IPI number, and my songs, when they're recorded, will have ISRCs. Excuse me 1 second. Been talking a long time. Okay, thank you. Online. How does APRA AMCOS pay YouTube music video clips? Okay, so again, as long as YouTube recognizes that it is a music video, they send us the most incredible sized files which contain data for every single stream of a music video within our territory. That data is fed into our system. It is matched up, probably using an ISRC, but also using track title, writer, duration, performer, all of that information matches up to our registrations. We can then keep it on your APRA member account. And as soon as we have enough of a royalty from YouTube, you will receive that royalty. And of course, YouTube have a license with APRA AMCOS to be able to make music available. So that's where that royalty comes from. They are paying us to be able to make music available. We take that money and we pay it based on the data that they give us. Music played online radio, is it eligible for royalties? Music played on online radio. Yes, it is. But online radio, digital radio, is basically paid at the same rate as a stream. So it is, again, a very, very low rate. But it is eligible for royalty. Another one, sorry, we're going on. And then I'm just seeing another couple of questions. I will just ask if everyone could please direct their questions to APRA AMCOS as opposed to the chat, just to help me so I can keep them in order. But there was a question there, how do we show YouTube it's a music video? If you Google YouTube's content management system, there is a how-to and there's instructions as to how to make sure that your music is being correctly identified at their end. Okay, so moving right along. Other. Do Australian artists need to join MLC if they co-write with US writer? Now, just to be clear, MLC is a brand new organisation that has opened up in the USA. They are looking after streaming services, essentially, digital, mechanical royalties, a very specific area of copyright, if you like. The happy answer here is no. Things in the US are quite different to how they're set up over here. Here in Australia, you as an individual songwriter can join APRA and AMCOS as an individual. Our organisations will work for you and collect both the public performance and the mechanical. And that mechanical fee is being collected from digital services as well as any physical reproduction. MLC is looking after US artists for purely that digital reproduction. So we're already doing it for you. You do not need to join any other organization to look after that. That's the short and happy answer. How do I stop covers of my tunes? Here's the sad reality, and it was one of the first awakening moments for me as a songwriter back as a teen. You can't. You actually cannot stop someone covering your work. When you join up with an organization like APRA AMCOS, you are assigning your right, you are handing it over, and people can cover your work. You're giving that permission, and you're allowing a royalty to be paid in return for that. That sounds really cold and really short, but unfortunately, that is how it works. So even a band that you might not be a fan of, and I don't want to offend anyone, so I'm not going to say any names, but someone you might not really want to cover your work can cover your work. Royalties for CCLI songwriters that aren't from churches or streams. Oh, I'm not 100% across what that's asking. I think it might be asking, can you join CCLI as well as APRA AMCOS? And I believe you could, but maybe contact us directly about that. I'm just not 100% sure what the question is in relation to. CCLI, for those who are unaware, is a Christian-based organisation looking after very specifically Christian songwriters and licensing churches. What happens if you receive royalties, particularly from overseas matchups of a song that you haven't performed? Well, I've actually just had to look after this for someone. It does happen. Occasionally, a performing rights organisation overseas might not quite read things. Look, I don't want to point your fingers. I don't want to name any names. Sometimes there is a mismatch, and performances for a song with the same title can be mismatched to you, and royalties can be incorrectly paid. Please just let us know. We will look into it, and you can actually just transfer any royalties back to us. If there is a situation where maybe those royalties might have already been spent, then we can look at other ways of remedying the situation. But for example, the one I'm working with right now, the writer contacted me. They said, I have definitely received performances of a work with the same title as mine, but it's not my song. And the performer name, I've never heard of these guys. They're from the UK. Clearly, there has been a mismatch. He just wants to know how to repay the money. I've given him APRA's bank account details, and he's going to pay it back. Simple as that. Let's have another look here. How do I collect international YouTube plays? That's coming into us, so fear not. While we only receive reports from YouTube for our territory, the PRS are receiving them in the UK for their territory, and ASCAP and BMI and MLC are receiving them for the USA, and different collecting societies are receiving them for their territories in Europe and Asia. But we all have reciprocal agreements. And what that means is that when there are royalties due to our membership, they are going to pass back to us any royalties and any data that's required for us to pay to our members. And likewise, when YouTube reports performances of songs for UK writers, US writers, French writers, Japanese writers, we collect that royalty here, we pass it back to their collecting societies, and they pay it on to their members. And that looks like it might, there was one question that I missed that was earlier up in the chat, but it had to do with a song you hadn't performed. So I think maybe I just answered it. Fab. Have we reached the end of the night? Are there any more questions? It's very strange when I can't see you. But I think we are at the end. It is 8:04, so we have technically gone 4 minutes over time, and I don't want to keep anyone from any creative endeavors. I'm sure you are all absolutely keen to get onto that new writer portal, check out all those new features, download that app, get on there, and really thank you so much for attending our webinar tonight. It's been fantastic. We have another one coming up next Wednesday night, so please sign on for that one as well. And have a fantastic week, guys. Feel free to reach out to APRA AMCOS anytime, live chat, email. We are slowly getting back on the phones as well. We would love to chat with you in person. Until then, take care. Have a great night.